20-0185, the state versus Graham Williams, Lindsay Rudder for appellant, Manny Arora for appellee.
May begin. Thank you.
May it please the court. My name is Lindsay Rudder. I'm here on behalf of the Fulton County District Attorney's Office and the state of Georgia appellant in this case. Appellant respectfully requests that this court reverse the lower court's July 17, 2018 order dismissing the indictment against appellee Graham Williams in this case. The trial court erred in three manners. First, the trial court erred by procedurally converting the evidentiary hearing into an illegal civil summary judgment, not available in criminal law. Second, the trial court erred in implying that there was constructive possession of the heroin between appellee and the victim in this case. And last, the trial court erred in narrowly defining the term distribution and the context of Georgia's Controlled Substance Act as being limited to the sale of a controlled substance. For each of these reasons independently, this court should reverse the lower court's dismissal. Turning first to the procedural issue. The dismissal in this case must be attached to one of the pretrial attacks in the indictment filed by the defendant appellee in this case. Appellee filed 3 attacks to the indictment. Although appellee states in its brief to this court that it did not file a general demurrer, it was filed and can be found at page 77 of this court's record as part of the defense consolidated motions. That was the first attack to the indictment. Next, on March 22nd of 2018, appellee filed a plea in bar alleging amnesty under OCGA 1613-5. And on that same day, he filed his last attack to the indictment, a challenge to the constitutionality of Georgia's felony murder statute laid out at OCGA 16-5-1. Looking at the transcript of the July 7, 2018 hearing, it's clear that the subject and context of that hearing was not the constitutionality of the felony murder statute, and there's no mention of that in the trial court's order, and therefore can be eliminated as one of the underlining motions that was used by the trial court to dismiss it. Turning next to the general demurrer. There was no discussion of the substance of the indictment as to the 4 corners of it at the hearing, and tellingly, the defense in this case concedes in its brief that it was not pursuing a general demurrer and that the substance of the indictment was sufficient. And therefore, that eliminates the general demurrer as the mechanism by which the trial court granted its order. We're now left with the plea in bar, which at page 24 of the hearing transcript, the trial court specifically limited the hearing to. And in fact, when appellee himself testified at the hearing and on cross-examination, the state sought to ask questions about what transpired prior to the victim being rendered unconscious, an objection was posed that it was outside the context of the amnesty statute and sustained by the trial court. Thus, it's readily apparent that that was the context of the hearing and should be the basis for the motion to dismiss. However, if you look at the last page of the order, which can be found in this court's record at 252, the court states it's dismissing the indictment. It's not based on the plea in bar. The plea in bar is moot. So we've eliminated the 3 bases for which the trial court could have based the dismissal. And we're left with the notion that the court illegally converted this evidentiary hearing into a civil summary judgment. In Schuman versus State, a case that this court ruled on in 1994 that can be found at 246 Georgia 526, this court specifically stated that that is an illegal procedure absent the consent, express consent of the parties, which there is no indication on the record here there was. There is no indication that the state sought for this to be a legal matter decided by the court, and there's no indication in the record that the appellee in the case requested a bench trial. Based on this, the trial court improperly prejudged the facts. And then moreover, most of our distribution cases, many of them derive from the Court of Appeals. And in Garcia versus State, 319, Georgia Appeals 751, the Court of Appeals specifically held that the matter of constructive possession, who actually possesses a controlled substance at what time and at what point, is a matter exclusively before the trier of fact, the jury. And the mechanism in which the trial court ruled in this case, it not only robbed the jury of its constitutional authority to be the trier of fact, it prejudged the facts and denied the state its opportunity to present its full case.
We do have some general demurrer cases where we call them speaking demurrers, and we allow the court to consider facts that are either stipulated or brought out at an evidentiary hearing. We say the parties have to consent, but are you arguing, I couldn't find anything that says express consent. Are you arguing that that needs to be very clearly consented to?
No, Your Honor. I think the law is clear on general demurrers that you can consent to it, and you can consent to it by waiver if it's turned into a speaking demurrer. However, for an illegal civil summary judgment, this court in Schuman found that there was express consent.
I don't really get, I mean, you argue, if it's a general demurrer and it's not expanded, a general demurrer is supposed to be on the face of the indictment, but we have cases that say you can also expand it beyond that. I understand if it's expanded beyond that without agreement, why you can call it summary judgment or something like that.
Yes, Your Honor. A speaking demurrer and civil summary judgment in a criminal matter are very similar, in fact, not the same thing.
And I'm trying to figure out why you say it's on that side, the summary judgment side of the line, not the speaking demurrer side.
It could be on either, but there was not any waiver as to a speaking demurrer because there was no discussion at all of the general demurrer to begin with, and Appellant consents in this, it's briefed to this court that it was not even pursuing a general demurrer, and it concedes to the sufficiency of the indictment. And therefore, there was no general demurrer to be converted into a speaking demurrer. And the parties solely briefed the plea and bar amnesty issue. There was no discussion beyond that. And in addition to it, the parties only agreed to one factual finding, that for the purposes of the amnesty plea and bar, that Appellant did inject the heroin into the victim. But beyond that, there were no factual findings made of which would have to be found for there to be any true ruling on a speaking demurrer.
Let's talk a little bit about the merits. Explain to me how injecting someone with a controlled substance amounts to distribution of that controlled substance within the meaning of the Controlled Substances Act.
Yes, Your Honor. That is a form of distribution because it's a transfer. In OCGA 16-1321, the Georgia Controlled Substance Act lays out its different definitions of the terms used in the Controlled Substance Act. In Part 11, it defines distribute as essentially delivery, which in the same code section at Section 7 is defined as the actual, constructed, or attempted transfer of an item from one person to another. Transfer is not defined in the statute, but turning to its plain and ordinary meaning, it means as one could pass to one person to another to give or to yield. That's the Black Law Dictionary definition. And the Georgia Court of Appeals, in defining delivery and thus transfer, has adopted that same meaning in Luster versus State. This court appears to have adopted that same broad interpretation in Holm versus State and Carter versus State, where distribution was the underlying offense for the basis of felony murder in those two cases. In each of those cases, an individual who gave an item to a victim who transpired as a result. Specifically in Carter, the victim was injected not with heroin, but with a liquid form of methamphetamine. And this court did not directly address this question, but did consider the sufficiency of the evidence and upheld the distribution charge in that case.
What about the aspect of the definition of distribution that says other than by administering?
Yes, Your Honor, it does say other than by administering or dispensing, but in OCGA 16-1321, it defines those as being limited to an action by a medical professional. And because Appellant here was not a medical professional or personnel, he could not administer or dispense, but could distribute because he did transfer it from one person to another. And in the trial court's order, it directly made one finding, that a distribution is limited to the sale of a controlled substance. It never made a ruling on constructive possession. It implied it by stating different cases that talked about constructive possession, but the only actual finding relates to the definition of distribution requiring it to be a sale. That is too narrow of a definition.
You say, I mean, administering and dispensing are limited to practitioners, but in the definition of administer, it specifically talks about administer includes injection.
Yes, it does, by a medical professional into the body of a patient or research subject. I believe it limits it to those two types of individuals from which it can be transferred into.
And then in the definition of dispense, it uses the term deliver. So we would have to read deliver, you say delivery includes injection.
Yes, as a method of transferring an item.
If we read that into the definition of dispense applicable to practitioners, we would say that delivery includes injection, except there's a different definition that says actually injection is administration, not dispensing. So if we plug your definition, your broad definition of delivery to include injection into the rest of the statute, it creates contradictions.
Your Honor, I believe you can limit the definition of injection to 161321 Part 7, where distribution is defined.
Right, so you would say in the same statute, in the same definition section, where the same words are used, injection means one thing as, well, delivery means one thing as to practitioners and a different thing as to non-practitioners.
Yes, Your Honor.
The same word.
Yes, Your Honor, because of the way it is written in the statute.
But the reason you're arguing it would be different is not anything about how it's written in the statute, because that provision uses the same word that you're arguing has a... Usually, when a statute uses the same word multiple times, we presume that that word has the same meaning every time it's used. Why doesn't it mean that here?
Because dispense and administer have a second step in which it only is limited in those instances to medical professionals. But likewise, there is a a canon of interpretation in which words in the statute should not be rendered useless. In the definition of, or in 161330, where it lays out the different acts it's criminalizing, it says that it is illegal to distribute.
It doesn't render it useless. There are a bazillion distributions that don't include injection, right? Your office prosecutes hundreds of those over the years, right?
Yes, certainly.
So excluding injection, how does that render the definition surplusage or useless?
Your Honor, I was indicating that in 161330B, the General Assembly lays out different acts that are criminalized: distribute, sell,
right,
etc. And because they use sell and distribute as two different words,
I agree with you that distribute and sell mean something different, but you have to convince us that distribute means inject. That's a different question.
Yes.
Are there any other states that have dealt with a similar issue based on a similar statute?
The federal statute defining distribute is exactly the same as Georgia's statute. It's laid out at 21 U.S.C. 841, and different circuits have held differently.
But I'm talking about states.
There has been a Court of Appeals case, actually, in Georgia where there was an injection. That's Carithers versus State, and of course, this court's own opinion in Carter versus State.
We didn't discuss it in Carter. So, you know, again, it's like the last case. Just because we did something, unless somebody said, hey, what about this? And we say, oh, the answer to that is this, that's not a holding.
Right, I understand, Your Honor. It's not a holding, but this court did consider the sufficiency of the statute, or excuse me, the definition of the distribution charge, and if an injection was not a method of transfer, then this court could not have upheld the sufficiency of that distribution charge in its case in Carter.
Back to Justice Warren's question, are there any other states that have similar statutes where this question has been definitively resolved?
And if you don't know the answer, I mean, you could certainly I'm sure with the chief's permission, file something later, but it just strikes me as that this is probably some sort of factual scenario that has happened more than once in the history of time. And if there are states whose statutes are similar, it would at least be instructive, though not binding.
The conceptual issue I think that I at least am struggling with is if I go to your house and I take with me my own drugs, meth, liquid meth, I don't know much about meth, and I hand it to you and say, here, pour that in my drink, and I drink it, you could be charged with distribution.
Answering your questions in turn, at first answering Justice Warren's, there are other states that have considered injection cages, and those are listed in the appellant's brief, specifically a Louisiana case. And in addition, there have been cases, going back to Justice Melton's question, where the person who did the transfer was not the original procurer or commercial distributor of that drug.
But in that situation I gave you, you would be charged with distribution, correct?
Yes, you do not have to be the initial commercial distributor, and that goes back to
So if I say, hold these drugs for a second while I pour my beer, you give them back to me and I pour them into my beer, have you distributed?
technically under the definition of distribute being to transfer, and the plain and ordinary meaning of transfer, yes, if you have knowledge of that substance, because it's not a strict liability crime, but if you have knowledge of it, technically, yes. And
the challenge here, really, counsel, is that the real problem in these scenarios by my colleagues is that you've possessed it knowingly, but we're trying to dodge possession. And so now we're trying to stretch distribution in a case where we would ordinarily consider it a possession, but possession's off the table because of the facts of this case.
Yes, Your Honor, it's off the table because this was more than possession. And answering your questions together, this would not just be the mere passage of an item back. There was a service provided here. The item that, and if we can even assume factually that this was the victim's heroin, again, that has not been addressed below and is a matter for the trier of fact. But if we can assume that hypothetically to be correct and the victim relinquished control to the defendant didn't return heroin in the form that it was given. He provided a service.
Just so it is not an unusual circumstance, I'm told, that people pass around a joint. Every time I take a joint, I pass it down the line. That is a distribution now, or any other illegal substance. You're smoking meth, you're smoking any other thing you can smoke, or drink, or eat, a marijuana brownie. I pass it to the next person who takes a bite, they pass it to the next person. That is now distribution.
I predicted that question. I actually found a case on point. Okay. And it is from a military appellate court, but they do define their statute as distribute, but they don't define it any further than that. In that case, it's exactly as you described. Everyone sitting in a circle passing a marijuana cigarette. The court found that that was distribution. That is Glassbrook versus the United States in, I believe it's 63 MJ 282.
Of course, in that scenario, there is actually a transfer of possession, correct?
Yes, and they each smoke it and pass it, but the court found that was also distribution because as each person held it, they had actual possession, and there was no constructive possession amongst the others.
Does an injection transfer possession? In other words, does the person who is injected now possess?
It has to be from from one person to another. And I know this court has looked at cases about something going into the fetus and into the body. And but technically, it does go into the person of another. But
does that person possess it once it's injected?
Yes. They would have internal possession of it. But I think if taking a step back, the more critical point is
haven't we held in Green versus State that the presence of cocaine metabolites in bodily fluid is evidence of the fact that cocaine was introduced into the body, but it's not direct evidence that the person actually possessed the cocaine?
Yes, Your Honor, you're correct. And I believe that was the case, one of the similar cases about the fetus, the metabolites being found in the fetus. But I think the greater point is that even if we can assume hypothetically the victim possessed heroin at some point in a powder form, and then it was given to the defendant in this case, he had actual physical possession of it at that point. There was no constructive possession.
But if we were right in green, that the presence of cocaine in the bloodstream is not direct evidence of possession, then how can your argument be right?
Because this is a transfer from one person to another.
But you're saying it's a transfer that didn't result in the other person having possession.
How is that a transfer?
He doesn't have to have possession of it for it to be a transfer into the body of the other.
Really?
It can.
What's your authority for that? I can transfer something to you even though you never get it?
My authority for that would be the cases, and I know it's not binding on this court, but this court's own opinions in which it's upheld the same fact pattern as distribution and thus a transfer.
Good morning, Chief Justice Melton, members of the court. If it pleases the court, my name is Manny Arora, and along with third-year law student Devin Rafis, we represent Mr. Graham Williams, the appellee for the first time in my 25 years arguing before this court today, so it's a little unusual sitting there. I want to address just the bloodstream issue in the military case that some of you took notes on. Having been a former JAG for 20 years and retired from the Air Force, prosecuting I don't know how many hundreds of these drug cases, the bloodstream issue in the state, it says that's not possession, but in the military it is possession, even having it in your bloodstream. The rules are completely different because of the severity of what you do as a military member, and I don't think it's even remotely applicable here in this case.
Is the text that military case was considering the same text of the statute we've got here?
No, Your Honor, it's different. Okay. It's the military manual for court martials. It spells it out completely differently. There's a lot of other factors. But to answer Justice Warren's questions, we've cited cases from Minnesota, Iowa, Louisiana, and other states, 2nd Circuit, 9th Circuit, 11th Circuit, 5th Circuit, that talk about what distribution is. So we should start off first and foremost with the correct...
Mr. Arora, before we get to the merits, which I think are very important, can you just quickly walk us through what is the procedural vehicle by which you procured a favorable ruling from the trial court?
We specifically said it was in a general demurrer because that simply means I can say no to the indictment on its face, and that's good enough. That's really not the case here, and we're not trying to argue it or call it a speaking demurrer or call it a summary judgment, any of that. It's essentially a plea in bar. Plea in bar meaning this case can't go forward for which reason.
A plea in bar, your only plea in bar, though, was under a different statute, the amnesty statute, right?
Correct, Your Honor, and it should have been a little better written by my office, but it wasn't, and that's my fault. The issue simply is in the plea in bars, what is the definition of distribution? Because if we sort of perverse it into what the state wants it to be, then the amnesty bill completely gets gutted and it's rendered meaningless. Because anytime anybody calls somebody to help save their lives or calls the EMTs, they're inherently sharing the drugs or they're in possession of the drugs. And as I put in the transcript to the trial judge, charge us with possession of the heroin.
That's not true. I mean, you can't call the EMTs because your friend OD'd and you had no possession or transfer. You had nothing to do with it other than being there, or you walk in on your child after they OD'd and call?
Well, that's completely different, Justice Namias, respectfully, because the point of amnesty is to prevent you from being prosecuted. So inherently, you have to have some liability in the fact of the drugs being used.
Well, it's to protect you from the risk that you will be prosecuted because you were there, or maybe you were doing something else, but it's not limited to joint possession.
I don't think I'm talking about you. I'm just simply saying, if a person could be subject to prosecution and they do the things that the amnesty law requires, that's the whole point of it. But in this situation, which is what we had here, is 2 people using drugs, or 4 people in this scenario using drugs, and somebody calls, they're not supposed to be prosecuted. If the idea of taking a marijuana joint or a syringe of heroin back and forth.
Even if you're right, the trial court did not grant your plea in bar under the amnesty statute, right?
Correct. The trial court simply, yes, ma'am.
Sorry, can we go back to Justice Blackwell's question too, which is you're saying the only operative motion was the plea in bar. Is that what you're saying? Or, I mean, tell me if I'm not understanding it correctly.
In my opinion, that would be correct because I didn't file a general, we had the omnibus motions where you have to file the demurrer, all that stuff within 10 days, but we didn't pursue it because the way I understand general demurrer is you have to say, can the indictment on its face stand? But what we're specifically talking the plea in bar is what does distribution mean?
Well, so let me take, okay, so let's just assume for the purposes of this question that only the plea in bar was operative. is it correct that the plea and bar was based on the amnesty motion or the amnesty argument?
We based it on the amnesty motion, trying to understand and explain what distribution means.
So that's what I'm really trying to get to, is does it cover both amnesty and the argument under the statute on distribution, or does it just cover the amnesty argument, which seems like it is a separate threshold, can a person be tried question?
I think it covers both things, and there was no objection by the state anywhere in the transcript when we sort of modified the hearing as the way it started going. We look at pages 23 and 24 of the transcript, and I put the issue solely here as the court put it out. This is simply a legal definition of what distribution means. And then if you go to page 64 of the transcript, the government, in fact, at the end says, we want to brief the specific limited issue about the legal definition of what distribution means. And that's what we spent most of the hearing
But
discussing.
doesn't line 19 and 20 really getting back to the issue of the amnesty applicability?
I think they're intertwined, Justice Boggs, and that's why I don't want to try to make it seem like I've done something that I haven't done. There is no definition of distribution in our state that would apply in this case.
Which is why a plea and bar would have been a more appropriate vehicle, would it not? You could admit the allegations contained in the indictment and not been guilty, correct?
Correct. And so
But you didn't file a plea and bar.
we did file the plea and bar, but it was based.
General demur, excuse me.
We didn't file the general demur because I didn't know if you can challenge the definition of a word. A general demur is more basic. It just says, if you read it on its face, is there a crime? They've alleged him with distribution. And
Isn't the definitions of words are typically the basis for a general demur, are they not? I mean, that's the whole point. You've laid out a specific definition that I can admit to every bit of and still not be guilty.
Well, you can't admit to distribution because you don't know, as indicted, how they're going to prove distribution, right?
right, I don't know the definition of distribution, and that's why I went the plea and bar route, saying this case shouldn't go forward based on a legal deficiency.
Was not the indictment specific that distribution was premised upon the injection?
No. We have to read the indictment. It
The
just,
felony murder count said that he was guilty, charged him with felony murder on the basis of injecting Mr. Ivy, or Miss Ivy, I don't know if that's a male or female.
Mr. Ivy, Your Honor, yes.
So for the felony murder count, it was based on injection. The second count's a little more general.
Yeah.
Right, and so the second count is the basis of the felony murder, so there's a more bill of particulars or something else like that we would need down the road, but we didn't have to go that far because my whole point in this case was, what does distribution mean? And you've got the amnesty statute that's been in existence for 5 years, and not a single DA's office has ever brought a case that I'm aware of, or at least that's been on appeal, that talks about sharing drugs.
If I'm a smart, under your definition, an injection of drugs is never a distribution. Is that right?
The case law that I've cited, Your Honor, I don't know if that's a definite hard no in all situations, because in the case law that we've started and the stuff that the government cites, where they say that there could be distribution, it deals with who brought the drugs to the party or to the event. And if somebody else brought the drugs to the party or individually brought them to the party and it wasn't jointly purchased or it was already there, then arguably in some of the states that I've cited, openly and honestly to the court, they've said that it could be distribution because you brought the drugs to the party and then you transferred your possession. So when you look at the transfer definition, which we don't have in our statute, and you look at the Black's Law Dictionary, it's always some amount of property interest. Because if you look at the Georgia cases, well, the Minnesota case under Carruthers that I've cited, it says the exchange of physical possession between two co-owners or two co-possessors is not distribution. And we've also cited other cases along the way from other states and federal circuits that talk about that, including Swiderski from the Second Circuit, Coots from Illinois, and even Luster, where you can't transfer the drugs to your fetus inside, which was a Supreme Court case, and we've got Edwards from California. In all those cases, people brought drugs to parties or injected each other or used drugs together, and the people were convicted based on definitions of distribution, just saying transferring is out there. And every single Supreme Court in those states, including the Federal Circuit, said, no, that is not correct, that's not distribution. And the reason I say that is the old Fifth Circuit, before it became the 11th Circuit in '78, under U.S. v. Zule, Z-U-L-E, and U.S. v. Littrell, L-I-T-T-R-E-L-L, say, as a matter of logic, a conviction for distribution cannot stand unless first there is possession with intent to distribute. So if we go into the possession with intent to distribute cases, they talk about how was it packaged? Was there cash around there? Were there scales?
That's just a proof issue. And my concern is, tell me exactly your definition, because the more your definition depends on facts, very specific facts, the less susceptible it is, certainly not to any kind of demurrer, and I'm not sure to a plea and bar. Plea and bars are not meant to be trials.
Correct.
So what exactly is your definition that excludes what happened here?
I'm trying to piece the definition together based on the cases from the federal.
Tell me the words you would have us put in a opinion in your favor that say distribution means this that does not cover my case.
Distribution means something more than simply sharing drugs at a certain amount, because we've got weights and all those criteria that we have to have. Distribution does not mean sharing a certain amount of drugs amongst consensual, voluntary people where the drugs are either.
So I'm not sure where that comes from. That comes from the case law that you surveyed.
Yes, Your Honor.
It does not rely on other than administering language?
No, Your Honor, because I haven't found.
Do you agree with the state on that?
I don't know if I agree with it, but there's just no case law to support their position, because there is a line about doctors and this and that, and I don't know how it fares in. I'm trying to keep it more simple by simply saying, when you look at the actual meaning, the plain context of the word, transfer that you all talked about, that's fine, but the context is drug distributor. Is a drug distributor the guy that hands the joint to the next guy? Or if Justice Boggs drops his pencil and Justice Benham picks it up, have you now transferred the pencil back to Justice Boggs? The transfer definition requires some amount of property interest. And what we have in this case...
Why would it not be? If Justice Melton drops his pencil and I pick it up and decide to keep it, I mean, once he drops his pencil and I pick it up, I have possession of it, right? It's not joint possession anymore.
But right. You're essentially stealing it. If the facts in this case were...
stealing, but stealing is still possession.
Let's go back to the presiding justice's hypothetical about the passing of the joint.
Yes, sir.
If I pass the joint to Justice Blackwell, I have transferred a property interest in that joint to Justice Blackwell, haven't I?
If it was your joint initially to do that, and that's what I said about the
Let's say
other cases.
Justice Bethel has a joint. He passes it to me. And the culture of the place that we're in is very different from the culture of the Georgia Supreme Court, and it's generally understood that then you're going to pass it down the line. Why is that not a transfer of possession?
The case law that I've cited talks about the physical possession being exchanged isn't the same thing as giving up your property rights to that, and that's what the cases from the other states talk about. And one thing I wanted to correct with the state, the judge did find...
Your point is, as I understand it, that two people who have joint possession of something already, passing the item back and forth between one another is not a distribution or a transfer of anything. Is that correct?
Correct. And that's what you go into when you look at the possession with intent cases. When you have that little joint in the glove compartment, there's 5 people in the car, and you charge everybody under the equal access and all those types of things. That's essentially what we have here. And so
if I'm asking you for assistance in managing my property,
yes,
you're never taking some sort of possession of it, though you may physically manipulate it or handle it. Is that your point? In other words,
yes.
I'm moving into an apartment building and you're in the parking lot and I say, could you bring that box in? By picking it up and bringing it in, you are never though you are manipulating it and you are handling it, you are never possessing it in the property rights interest sense?
Of course, absolutely correct. Because I can't go and take and sell that sofa, and I can't sell that TV because
in the same way that if I say, hold my beer for a second,
right,
that beer's not yours to drink.
Correct.
While you're holding it.
Correct. And so the other thing that the judge found on his order, as I've cited here on page 2.
But before we move on from that point,
yes,
though, I get your point about the way the indictment is structured, where it just says distribute with respect to the distribution count, unlike the felony murder. You don't know how that's going to be prosecuted.
Right.
Why isn't it the case that there are just certain claims of immunity under the amnesty statute that are so fact-specific they're not really subject to litigation at this early procedural stage of the case?
If we did that, Justice Peterson, I'm asking you to look at the justification, which I argued in Bunn many years ago, and we look at motions to suppress and things of that nature. Those are fact-specific as to how the law applies. We're trying to figure out what the definition of the word distribution is. In this case, we're being fact-specific because we don't have a definition.
But you're trying to do more than figure out what distribute means. You're trying to figure out whether that meaning actually happened in this case based on the specific facts of this case.
I wouldn't disagree with that, but until we actually have what the definition is, then everything becomes a chicken and the egg situation.
No, let's take your definition.
Yes, sir.
Are all the facts, I mean, the fact that it was joint possession and voluntarily administered and all that, was that stipulated to?
It's right there in the order from the court.
No, I know the court said it because that's the evidence, you put on some evidence. Was it stipulated to? We normally don't let courts find disputed facts if they could come out differently at trial, and sometimes we do, but
Sure.
But that's my concern is you say, oh, these are all the facts because the court said they were the facts, but normally that's why we have trials.
I think in the motions here, and I wish I could cite to it, I don't think anybody disputed the fact based on all the discovery that was presented in the testimony by the state or ourselves saying that the drugs were already there.
Not disputing it is different than agreeing to it.
Would you agree that the amnesty statute itself presupposes some pretrial determination of these issues? Because the amnesty statute does not say that a person entitled to amnesty can't be convicted. It says a person entitled to amnesty shall not be charged or prosecuted.
Correct. And so we did the same thing when we did justification. This court 15 years ago ended up ruling that you get a pretrial hearing on justification because what would be the point of having it otherwise?
Right. So the trial court maybe can have a plea and bar hearing, evidentiary hearing on amnesty, and then grant your motion based on amnesty. But the trial court here expressly said your motion based on amnesty is moot, right? I'm granting your motion based on a plea and bar based on definitions.
The amnesty thing we simply used as a tool to sort of explain how the case law is modified since the drug statute.
What I'm trying to figure out is, I get that. There is a pretrial procedure for saying, just like I'm immune based on self-defense, I'm immune based on amnesty.
Yes, sir.
Except the trial court didn't do that here. Maybe the trial court could, or maybe we're supposed to read its order that way, but the trial court expressly said, I'm saying that's moot. I'm granting a plea and bar based, or actually, trial court says I'm granting a motion to dismiss based on the definition of distribute.
What is the motion to dismiss that the judge granted?
We're talking about the definition of the word distribution. The motion to dismiss applies because amnesty technically doesn't apply to this indictment because you're charged with distribution, not simple possession.
What motion did you file? What was the motion that procured the order?
We filed a plea and bar talking heavily about amnesty as it applies to the definition of what distribution should be.
So the judge granted a motion that wasn't filed.
It was filed, and what I would say under Marshall versus State, which is...
The judge says the plea and bar is moot. The plea and bar is the motion that you filed. So then the judge dismisses the case. I mean, maybe there's a process by which a judge can sua sponte grant a dismissal, but...
He dismissed it based on the definition of what he found, and he was saying, therefore, the amnesty wouldn't even apply because...
But that definition, he can only apply based on certain facts. He can't apply it based on the indictment, right?
Correct.
Because you would lose. He has to apply it based...
Well, I'm not so sure.
Well, maybe you would lose at least on the distribution count.
Correct.
So maybe it's a general demur on count one.
I mean, on the first page of the court's order, it says, this case came on for hearing on the defendant's motion to dismiss and defendant's plea and bar based on the amnesty law. Did the judge mean there's a motion to dismiss based on amnesty and a plea and bar based on amnesty? Or is there some other motion to dismiss? That's what we're trying to figure out is, when you had the hearing, what was before the court?
There was no other motion to dismiss, but we argued...
There was a motion to dismiss as unconstitutional, right?
Correct.
Labeled a motion to dismiss.
Yes, Your Honor.
So there was a motion to dismiss.
Right, but not as to the facts that we're talking about here today. And I don't want to, pontificate on something.
Justice Blackwell asked you when he said the hearings on the motion to dismiss, that was on your motion to dismiss, right?
Correct, but it just didn't deal specifically with the issue that we're talking about here as to the distribution definition. And so what I say under Marshall is we're getting into nomenclature and semantics of it. If the answer is right under the right for any reason rule doctrine, if we need to go down that load, because I've lost before this court for that multiple times on cell phones and everything else, the right answer is the right answer. And the reason you talk about the amnesty bill is it's supposed to be there to protect those folks so they actually call people and save lives down the road. If multiple people at a party or an event are using drugs together, and that's going to be distribution by handing it or shooting it, if it's under 4 grams, all that, then there is no more amnesty. And you have to ask yourself, why in 5 years has this never been prosecuted before that's ever come up here on a defendant's motion or a prosecution's motion? Because this same office, where I cited Judge Shube's order on a similar case a year earlier, didn't bother to appeal that. But this time, another DA picks it up and says, we are going to appeal it. The random nature of it all and the fact that there's no history with this statute, you would essentially make it meaningless and say, legislature, you're wrong. We don't care about amnesty. The whole point of amnesty is we're using drugs together because I have a risk of going to jail if I call the police, but we want you to do that if you meet the criteria of under 4 grams. You can assist in some way, call the 911, all those other things.
So I hear you saying we should affirm on the amnesty ground as amnesty right for any reason.
Amnesty would, I'm talking about right for any reason on the distribution because we don't get to amnesty.
What is the distribution? Is that a motion to dismiss? Is it a general, what do you want us to say is right?
It's a plea and bar and a motion to dismiss both ways based on the definition, because if we went to the amnesty issue, they have to charge us with possession first. Until I'm charged with possession, the amnesty bill can't protect me. Thank you.
Thank you, sir.
Okay, move forward.